game show over there. But here we are, we're back, ready to go. Here we go. Let me get my last pieces here sorted out. All right, there we go. Yay, here we are, Happy to be here. Welcome in, everyone. Let me get my little sticky notes sorted out for tonight. Hello, Alan. Hello, Kaya. Good evening, good evening. Good evening, Mo Girly Girl, Kathleen, Kimberly. Hi, Heather. Sarah, good to see you. Hi, welcome in. Yay, Casey, Vicky. Oh my gosh, good to see everybody. Here, let me just write out my sticky note. American Federation of Teachers. Right, we've got a great order to go through tonight on the DOGE situation. The more I learn about the DOGE, the more I'm like, really? Is this really a thing that's happening right now? Then it's like, yes, it is. Shoot. Oh my gosh. All right, here we go. Let me make sure I get my final pieces on here. 2, 4, 3 up. All right, there we go. Hello. Hi, Kathy. Terry, hello. Good to see you, Cynthia, June Marie. Hi there, John. How you doing? Hopefully you're having a good day. I'm so glad you could all come by tonight. So I've been off for a few days. What I'm finding to try to get into the the schedule here, what I'm finding is that it's hard for me actually over the weekend. Saturday and Sunday, for some reason, have been hard for me to come on, but Mondays are looking super good for the YouTube. I like to start my week by going live on YouTube, although I did do a pre-game show, everyone, over on the TikTok, just going through the closet door of litigation, and I will be posting that live later tonight or tomorrow as soon as I possibly can. So there's that. We are in approximately, for the lawsuits, we're in the 86 range. So somewhere around that number. We have a hello, Willie B again. Hello. Enjoy the chuckling. Well, there's a lot to chuckle about. I think that's very important. Hello, Achilles. Good to see you. So we're kind of in that 85 to 90 range for the number of lawsuits that have been filed. I think there might have been one today, but mostly the courts are just doing hearings, reading briefs, getting everything set. You have to remember, for each of these cases, there's an entire process and potential trial. Yeah, potential trial for each one of these cases. So it's a lot. It's a lot of work. Got here in time. Yay, Matthew. Welcome in. I'm glad you were able to join. So with all of those lawsuits, we of course have a ton of attorneys and law firms that are involved. We've got unions that are suing, so they usually have counsel, in-house counsel that they're using. So we're not talking like a bunch of pro se people. Not that there's anything wrong with that, but it is harder to fight the federal government if you're pro se. I'm just going to put it out there, as opposed to being an experienced federal trial litigator. That's just kind of what the facts are. Every wall in your house. Well, I got these 2 huge, enormous foam boards. And so there may be some things that are moving depending on, my categories are filling up. Like the DOGE cases keep coming. There's just so many under that category. So we might be doing that at some point. We'll have to see how it goes. But yeah, there's a lot, everyone. And it feels overwhelming until you break it down. So I have to again say to Just Security, what an amazing website that is. I highly recommend it, everyone. I can go through and take you through these cases and look at the paperwork and kind of explain how things work. But I tell you what, Just Security, that's some heavy lifting that they're doing over there. So very thankful for them and their website. Highly recommend taking a peek over there if you're wondering what the litigation is. So needs to have a lot. Well, and they do, Kaya. They need to have a lot, and then they do have a lot. So there's a lot going on there. Sorry, everyone. My hair has just not even been tamed. I tried to tame it earlier, and it wasn't happening. So hopefully everyone's having an okay Monday. Nothing too horrific yet. I will probably do one more headlines update later tonight. I'm having a lot of fun doing that actually. Just looking at the news for like 5 minutes and then, run away. Run away from the news. So, what I've got for everyone tonight, we have an order that just came out of Maryland. This is one of the DOGE cases. And I really like how the judge set this out. She gives us a great history of DOGE, which is like nothing. There is no history. So she does a great job of kind of sorting through it. Hello, meme NATO. So she does a really good job in kind of explaining actually how these committees are supposed to work, which is not what's happening here. So, that's a problem. And she came in, she's got a 33-page order here, and I will not be reading word for word here, but we'll kind of skip through and get to those highlights that I think are really important here, explaining what it is, what it does, and why there should be a restraining order granted. So she did grant this temporary restraining order again, which is only temporary until things start get going in court, and then the restraining order is usually no longer necessary. So here we go. I'm going to dive on in, everyone. And thank you, moderators. I appreciate all that you do all the time. I appreciate it so much. Yeah, exactly. I'm not really here to, convince anybody. I'm just here to read what the ruling is here. So we don't need too much negative energy. Here we go. American Federation of Teachers versus Scott Bessent. And we've got our case number here. This is document 38. If you're looking this up online, there is a court listener file that you can go and check out if you're interested. We are in Maryland here. And we'll just dive right in. Memorandum opinion and temporary restraining order. This lawsuit is one of several filed by plaintiffs who seek to enjoin federal government agencies from disclosing records with their sensitive personal information to government personnel affiliated with the newly established Department of Government Efficiency, DOGE. The plaintiffs in this suit are unions and membership organizations representing current and former federal employees and federal student aid recipients, and 6 military veterans who have received federal benefits or student loans. So as I pause here for a minute, what is really noteworthy here is that in a lot of our cases we have in general. So in general, we're here for, the workers, or in general, we're here for the labor board or the FBI agents. But here we have specific people that are being pulled out. And here, 6 military veterans. So we have some individuals who are claiming harm, and that is going to make a really big difference in a lot of these cases. So that's what also makes this one a little bit different than the others so far. I'm hoping this will become a trend. In their amended complaint filed on February 12th, the plaintiffs assert claims under the Administrative Procedure Act against the United States Department of Treasury, the U.S. Department of Education, the U.S. Office of Personnel Management, Scott Bessent, the Secretary of Treasury, Charles Ezell, the Acting Director of OPM, and Denise Carter, the Acting Secretary of Education, collectively called the government. The plaintiffs allege that the agencies unlawfully granted access to records that contain their personally identifiable information, or PII. We'll just call it PI, I don't know, to personnel implementing the president's executive orders on the DOGE agenda. The plaintiffs have moved for a temporary restraining order to enjoin the government from granting access to record systems with their sensitive personal information to individuals who are implementing the president's DOGE agenda. The government filed an opposition and the plaintiffs replied. The court held a hearing on February 19th. So I think it's important we have to flip our mindset. Typically, for me at least, when I'm looking at the government from a prosecutor point of view, I'm saying, well, the government's fighting the good fight. That is not the case. That is not the case in all of these lawsuits. The government here is not here to really fight the good fight. The government here is to take orders from Mr. Trump, and that is a significant difference than what we've had before. Upon consideration of the amended complaint, the temporary restraining order briefing, the limited record evidence, oral argument, and recent decisions of other courts in similar cases, of which there are about a dozen, the courts find that the plaintiffs have met their burden for the extraordinary relief they seek. Again, these TROs that we're hearing about, everybody, are unusual. This is kind of a only in extreme situations kind of order. The TRO is granted in part and denied in part. And then we have footnote number 1, which is huge. I feel like this is a abuse of footnotes. Here we go. Other courts recently have denied temporary restraining orders in similar cases, and she's citing those here. The TRO against the United States Department of Labor, Department of Health and Human Services, the Consumer Financial Protection Bureau, the U.S. DOGE Service, and the U.S. DOGE Services Temporary Organization, because plaintiffs did not establish the likelihood of success on the merits, which is one of the keys to being able to get this kind of a restraining order, is that you need to show that it's likely the plaintiffs will win as litigation goes forward. And so she's going through and naming the rest of all of these here. We've got denying the temporary restraining order against education and acting Secretary of Education because plaintiffs did not establish irreparable harm, and that's the other element. So we two pieces there that need to be in place. And denying the restraining order against OPM and agency heads because plaintiffs did not establish irreparable harm. So we have the irreparable harm element here and the likelihood of success element here. So we have to get those two elements into play if we're going to go forward. One court's granted a TRO and preliminary injunction. On February 21st, a district judge in the Southern District of New York granted a preliminary injunction that effectively gives the plaintiffs, in this case, the relief they seek against the Treasury. The court ordered in part the United States Department of Treasury and the Secretary of Treasury are restrained from granting access to any Treasury Department payment record, payment systems, or any other data systems maintained by the Treasury Department containing personally identifiable information and or confidential financial information of payees to any employee, officer, or contractor employed by, affiliated with the United States DOGE service. A DOGE or the DOGE team established at the Treasury Department pending further order of this court. The scope of the preliminary injunction includes Treasury records with the plaintiffs' PII. Thus, the plaintiffs cannot establish that they will be irreparably harmed if this court does not grant the TRO against the Treasury. For this reason, their motion for a restraining order against the Treasury and Secretary Bessent is denied. So I think it's important. She's just, in a footnote, went through and explained some cases have been successful, some have not, and why they weren't successful. So that's incredibly helpful. I do have those decisions too where it was denied, and I will be going through those at another time. So here's our background. I'm just going to do kind of this intro paragraph here to tell you what the executive order is about, and then we'll kind of skip through. So background, DOGE executive orders. On January 20th, President Donald J. Trump signed an executive order called Establishing and Implementing the President's Department of Government Efficiency. Here's the executive order. The DOGE executive order established a Department of Government Efficiency to implement the President's DOGE agenda by modernizing federal technology and software to maximize governmental efficiency and productivity. The order renames the United States Digital Service as the United States DOGE Service and establishes the U.S. DOGE Service Temporary Organization to be dedicated to advancing the President's 18-month DOGE agenda. So let's pause for a minute. So one of the things that kind of, drives me a bit bonkers is that they think that just because they took a committee or they took a department that was already there and renamed it, that, it's fine. So we have everything in place to comply with federal laws, but we just renamed it and we have this 18-month agenda. And, no, that's not how you do it. It directs each agency head to establish a DOGE team of at least 4 employees which may include special government employees hired or assigned within 30 days of the date of this order. So, and this is something I didn't realize either, that all the departments needed to have mini DOGE departments. Oh, all right, Chad, did you all know that that was there? That they're required to put together a DOGE team in all of the major departments? Did you know that? Yeah, I agree. Had no idea. Yeah. Yeah. Okay. This kind of a big deal. This kind of a big deal, everybody. Let's highlight this and make sure that we uh, share this information with our friends, all right? So not only is DOGE its own entity, but it also is supposed to have its tentacles in other areas, in other departments. So that's why this is so important to figure out exactly what the agenda is and whether or not it's allowable, because they're all over the place. Next, each DOGE team will typically include one DOGE team leader, one engineer, one human resources specialist, and one attorney. Yikes. This is why they put that call out for all the attorneys for P25, I think. And DOGE team leads will coordinate their work with the USDS and advise their respective agency heads on implementing the president's DOGE agenda. So this is really, this is kind of scary crap here. The DOGE executive order directs the USDS administrator to commence a software modernization initiative to improve the quality and efficiency of government-wide software, network infrastructure, and information technology systems, which includes working with agency heads to promote interoperability between agency networks and systems, ensure data integrity, and facilitate responsible data collection and synchronization. The executive order commands agency heads to take all necessary steps in coordination with the USDS administrator and to the maximum extent consistent with the law to ensure that the USDS has full and prompt access to all unclassified agency records, software systems, and IT systems. Also directs the USDS shall adhere to rigorous data protection standards. Yeah. No, I didn't know. I know, right? Oh my gosh, it's not. Let's just go ahead, because she does set out here exactly what the issue is for this case. On February 11th, President Trump signed an executive order called Implementing the President's Department of Government Efficiency Workforce Optimization Initiative, because we need that as the title. The Workforce Executive Order commences a critical transformation of the federal bureaucracy. It proclaims that the Trump administration will empower American families, workers, taxpayers, and our system of government itself by eliminating waste, bloat, and insularity. In a section titled Reforming the Federal Workforce to Maximize Efficiency and Productivity, the order directs the Office of Management and Budget to submit a plan to reduce the size of the federal government workforce. B, agency heads to develop a data-driven plan in consultation with its DOGE team leader. This is really so stressful thinking about this. All these teams all over the place, right? That's very stressful. To ensure new career appointment hires are at the highest needed areas. C, agency heads to prepare the initiative large-scale reduction in force. D, OPM to revise regulations on fitness and suitability criteria. Yikes. And E, agency heads to submit to OMB a report that identifies any statutes that establish the agency. Oh my gosh, do your work, everybody. Do your own work. That identifies any statutes that establish the agency as statutorily required entities and discuss whether the agency should be eliminated or consolidated. And F, the USDS administrator within 240 days of the order to submit a report to the president regarding implementation of this order. Wow, this is a lot. This is really bad. This is really bad, everybody. Oh my gosh, we're gonna put a little yikes here. Yikes. Oh my goodness. All right, agency defendants. Number 1, education. Education manages the federal student loan system. Within this system, the Federal Student Aid Office maintains the National Student Loan Data System. The Common Origination and Disbursement System and Future Act systems and financial management systems. These systems house records that contain personal information of individuals who either apply for or receive federal student aid, such as social security numbers, taxpayer identification numbers, names, addresses, date of birth, email addresses, income and asset information, tax information, marital status, demographic information, including citizenship status, and family members' personal and financial information. Yikes! The DOGE affiliates at education include Adam Ramada, a USDS employee detailed to education, and 5 other DOGE affiliated individuals who play the principal role in helping to advance the mission of President Trump's executive order. This is so awful. Footnote 2. The court uses the term DOGE affiliates throughout the opinion to refer to the personnel at education and OPM who are working on the DOGE agenda and have been granted access to the records containing personal information at education. This includes Adam Ramada and the DOGE affiliated individuals granted such access as described in Ramada Supplemental Declaration. Oh my gosh, everyone, this is bad. These individuals are assisting the Department of Education with auditing contract, grant, and related programs for waste, fraud, and abuse, including an audit of the Department of Education's federal student loan portfolio to ensure it is free from, among other things, fraud, duplication, and ineligible loan recipients. They also help senior department leadership obtain access to accurate data and data analytics to inform their policy decisions at the department. These individuals primarily worked to identify contracts and grants that are wasteful, abusive, or inconsistent with the leadership's policy priorities. Oh, my goodness gracious. Oh, goodness gracious. Oh, sorry, everybody. This is really bad. This is really bad. DOGE affiliates at education have been granted access to department information, technology, and data systems. This includes records that education maintains in its operation of federal student loan programs. Here, the relevant employees require access to the Department of Education information technology and data systems related to the student loan programs in order to audit those programs for waste, fraud, and abuse. DOGE affiliates at education are also expected to access tax-related information maintained by education in the future. OPM acts as the Chief Human Resources Agency and Personnel Policy Manager for the federal government. For example, OPM maintains the electronic official personnel folder, which contains digital versions of the federal employees' personnel files that cover their entire period of federal civilian service. This is so creepy. Here we go. Let's bump down. Other than Hogan, there are 5 key system engineers working on OPM. None of the 5 individuals has access to the EHRI, though that could change if their duties require access in the future. Hogan periodically reviews access to these systems. In early February, he directed his team to remove access for 3 engineers whose job duties do not require prospective access. So she's saying access was given to those who should not have it. The plaintiffs. The organizational plaintiffs are the American Federation of Teachers, International Association of Mechanics and Aerospace Workers, International Federation of Professional and Technical Engineers, National Active and Retired Federal Employees Association, National Federation of Federal Employees. AFT represents over 1.8 million people employed in the teaching and nursing profession. All right, let's skip down here. We'll just skip. So the plaintiffs assert 3 violations of the Administrative Procedure Act. First, the agency's actions violate the Privacy Act. Second, the agencies acted arbitrarily and capriciously when they failed to consider the requirements of the Privacy Act and failed to engage in reasoned decision-making when they granted DOGE affiliates sweeping access to their systems of records containing sensitive and personal data. Finally, the agencies violated their non-discretionary duties to protect records from unauthorized disclosure. This is huge. This is really huge. At this point, we're going to see this argument over and over and over again, that we've got the actions being done by DOGE are arbitrary. And that's one thing that you can't just do. You can't say, well, man, we're just going to do whatever we want. I mean, this is the federal system. This isn't some, private company out in the Bronx where you can just kick people around. Nope. So next is the discussion. They'll set out jurisdiction. Every court's going to do this. So jurisdiction, first she is addressing this issue of standing. Here, I'm not going to take a lot of time on this. Standing is its own issue and can take a really different turn for a while. I would say, of course, if you really want to know about standing and how it works, one of the biggest cases is, of course, this landmark case out of 1992. This is Lujan versus Defenders of Wildlife. So this is kind of how it's set out if you, being part of an organization, actually have standing. So that's a great case to take a look at. So she's going through, obviously standing has been established because she went forward with this order. So I'm going to kind of skip through here to our next piece, because there's a lot in here on standing. And the reason, again, why it's so important is that's an appealable issue. The defendants, if they don't like her answer, can come in and say, well, they didn't have standing. So she needs to put it out and explain it very carefully for any kind of an appellate situation that will come up later, because all of this stuff is going to be appealed at one point or another. Why not? It's the Department of Justice defending it, so Mr. Trump doesn't have to pay him. So why not? Why not go the full distance with everything? Okay, got to get the tang going here. It's tang time, everybody. Next, judicial reviewability. The Administrative Procedure Act allows for judicial review of final agency action. This is the key. It has to be final. And you'd be surprised how many cases actually struggle in getting it to that final agency piece in order to move forward, for which there's no other adequate remedy in court. The government argues there's no final agency action and the plaintiffs have an adequate remedy under the Privacy Act. So again, this is exactly what the defendants are saying here. Final agency action, and I do want to take a little time going through this because her analysis sets it apart from other cases because of this final agency action element, as well as the individuals. Yep, I've got the tang. I've got tang going. Oh my gosh, it's my comfort drink, everyone. I should put some rum in it someday. I'll probably do that at some point. Give me a couple more weeks. I'll be sitting out here with the coconut rum. All right, and I'm of legal age, so that would be appropriate. That would be okay. Here we go. Final agency action. Agency action is final when two conditions are met. Get anything in the legal field, we need a test, and then we have to meet that test. Number one, the action must mark the consummation of the agency's decision-making process. It must not be of merely tentative or interlocutory nature. And two, the action must be one by which rights or obligations have been determined or from which legal consequences will flow. And that's citing case law that set out those tests. In the Venetian Casino Resort case versus the EEOC, the DC Circuit concluded that an agency's decision to permit its employees to disclose confidential information without notice was a final agency action. All right, so this is one of the keys here, one of the keys to the case right here, or keys to the castle. There, a company operating a hotel and casino filed suit against the EEOC. Venetian asserted that the EEOC violated the APA through a policy that allowed the EEOC's employees to disclose an employer's confidential information to potential plaintiffs without first notifying the employer that its information would be disclosed. The EEOC argued that Venetian could not bring an APA claim because the challenged policy appeared in its compliance manual, which was not a final agency action. According to the DC Circuit, EEOC's argument was misdirected because the final agency action at issue was not the manual, but rather the decision of the commission to adopt a policy of disclosing confidential information without notice. The court determined that the agency took final action by adopting the policy and that the action was subject to judicial review. Again, we're setting this out because she's just halting this final action argument just before it can even get any momentum at all. So, and I can appreciate that from our judge here. Yep. All right. Ultimately, the Venetian court found that adopting a policy of permitting employees to disclose confidential information without notice is surely a consummation of the agency's decision making process, and one by which the submitter's rights and the agency's obligations have been determined. Citing further case law here. And the DC Circuit remanded the case for entry of an injunction prohibiting the EEOC from disclosing Venetian's confidential information pursuant to its current disclosure policy. Here, as in Venetian, the decisions to grant DOGE affiliates access to agency record systems were final agency actions. So again, this is the key. She's saying, yes, you've met the test. You have met the test. This is a final agency action here. Education and OPM granted DOGE affiliates access to systems that contained records of the plaintiffs. The decision to grant access was neither tentative nor interlocutory in nature. It was the consummation of the agency's decision-making process. There was nothing further for the agencies to do to formalize the decisions. No written decision was required to finalize the actions. And she's citing further case law here, which I'm going to kind of buzz through here. And while the agencies have the authority to revoke and restrict the access, that authority does not make their decision tentative. The agencies decided that DOGE affiliates could access their record systems, and the DOGE affiliates did so. The agency actions marked the consummation of their decision-making process. And here, as in Venetian, Education and OPM adopted a policy of permitting disclosure that determines the plaintiff's legal rights and the agency's legal obligations. The Privacy Act prohibits disclosure of the records at issue except pursuant to a written request by or with the prior written consent of the individual to whom the record pertains, unless the disclosure falls within an enumerated exception. So this is, oops, oh no, the tang almost bit at everybody. So this, again, we're going to see this over and over and over again. This particular law, this section of the law, is what's going to be fought over in all of these cases, all right, under the Privacy Act. So kind of keep that in mind as we go forward here. The agencies have determined that to comply with the Privacy Act, they do not need the plaintiff's written authorization to disclose their records to DOGE affiliates. Thus, OPM and Education made determinations about the plaintiff's rights to protect their personal information and the agency's legal obligations under the Privacy Act. Tequila Sunrise. Oh my gosh, that would be great. The agency decisions to grant DOGE affiliates access to the plaintiff's personal information are final agency actions. Again, here's the key, everybody, right there. No adequate remedy. The government argues, and this remedy, again, is what's going to happen if your private information is taken, right? The government argues that the plaintiffs cannot seek relief under the APA because they have an adequate remedy available under the Privacy Act. They do not. All right. The Privacy Act provides a cause of action for damages when an agency improperly discloses records. It does not provide a cause of action for injunctive relief in these circumstances. Thus, the plaintiffs do not have an available remedy under the Privacy Act. Instead, they can only bring an action under the APA for injunctive relief. And then we're pulling in case citing, recognizing that while injunctive relief is not authorized by the Privacy Act for unauthorized disclosure of records, we do not read these cases to stand for the proposition that the government may not be enjoined from violating the Privacy Act by disclosing personal information. And we'll skip forward. So we've got a temporary restraining order here. So she talks about that just a little bit. Again, very unusual. Temporary restraining orders only in the most extreme situations. The standard for a temporary restraining order is the same as a preliminary injunction. The party seeking the temporary restraining order must establish 1, they're likely to succeed on the merits, 2, they're likely to suffer irreparable harm if preliminary relief is not granted, 3, that the balance of equities favors them, and 4, an injunction is in the public interest. So again, here's our 4-part test, and we've already seen this in multiple filings and orders from the courts already. And how long are restraining orders good for? Just until there's a hearing at a point where a judge can make a decision and lift the order. So the judge will ultimately decide when it expires, either by setting a date or by saying it, from the bench. Number 1, likelihood of success on the merits. So will the teachers succeed in their case? Let's see what the judge thinks. The plaintiffs have shown a likelihood of success on the merits of their APA claim that education and OPM took final agency actions not in accordance with law. So this judge thinks that they've got a pretty good case. And sometimes when that happens, you're already done. Like, we just won't go further in litigation. We're like, nah, fine, whatever. But in these cases, no, I think it'll keep going every single step because, of course, it's the Department of Justice and not Mr. Trump's own money. Specifically, the plaintiffs have shown that education and OPM likely violated the Privacy Act by disclosing their personal information to DOGE affiliates without their consent. And then we have footnote 7 here. The plaintiffs also have shown that they likely have standing. Again, that standing issue is huge. They must support each element of standing with the manner and degree of evidence required at the successive stages of litigation. And then she's citing the Lujan case here, which we kind of already talked about. I'm not going to go through the standing argument here, but it is on page 20, footnote 7, for anyone who is interested. The Privacy Act prohibits agencies from disclosing any record which is contained in a system of records by any means of communication to any person or to another agency, except pursuant to a written request by or with the prior written consent of the individual to whom the record pertains. The Privacy Act defines a record as any item, collection, or grouping of information about an individual that's maintained by an agency, including but not limited to his education, financial transactions, medical history, and criminal or employment history. And that contains his name or the identifying number, symbol, or other identifying particular assigned to the individual, such as a finger or voice print or a photograph. Yeah, it's always weird when you put your fingerprints on file, everyone. I'm still uncomfortable with that. I had to submit my fingerprints when I took my bar exam. And so, you go into a cop shop and you're like, I got to have my fingerprints in order to take this test. You have this big sheet and they go through and take your fingerprints. Meanwhile, someone's in there getting booked and they're doing fingerprints. You're like, well, this is awkward. And then you turn it in and there you go. It's like, well, here's my personal information on my fingerprints. You can have that. Really? You didn't do that? Oh my gosh. Yeah, I had to do it. Maybe it's because I'm so old. Maybe they don't do that anymore, but yeah, it's a little bit off-putting. All right, next up, and we've got footnote 8 here. The Privacy Act does not define disclosure, but agencies have interpreted the term to include granting access to records. So I think that disclosure piece, I'll go ahead and highlight because that's going to be another important element that these other judges are going to have to deal with, is this piece. We're looking at the guidelines, Federal Register. A disclosure may be either the transfer of a record or the granting access of a record. Disclosure means providing personal review of a record or a copy thereof to someone other than the data subject or the data subject's authorized representative, parent, or legal guardian. Likewise, courts have construed the term liberally to include not only the physical disclosure of the records, but also the accessing of private records. And then we've got case law down here. So again, this is footnote 8. If you really want to get into the weeds of disclosure, that's on page 21. There are exceptions to the Act barring on disclosure, and I'm not going to spend too much time on that either because we don't have that situation here. The government insists and the court assumes for the purposes of the restraining order motion that the DOGE affiliates are employees of education and OPM and that the disclosure of plaintiffs' records is within the agency that maintains the records. The question then is whether DOGE affiliates have a need for the record in the performance of their duties. So again, just arguing here, like, well, we have to have this information versus, uh, no, you don't. You don't need to have that in order to do your job. Education. Currently, there are 6 DOGE affiliates working at education. Adam Ramada and 5 others who have not been identified by name. Ramada is a USDS employee detailed to education. He and the 5 DOGE affiliated individuals who work with him at education play the principal role in helping to advance the mission of President Trump's executive order. Ramada's duties include assisting the Department of Education with auditing contract, grant, and related programs for waste, fraud, and abuse, including an audit on the Department of Education's federal student loan portfolio to ensure it is free from, among other things, fraud, duplication, and ineligible loan recipients. DOGE affiliates at education help senior department leadership obtain access to accurate data and data analytics to inform their policy decisions at the department. Ramada and the 5 other DOGE affiliates have primarily worked, oh, this is so distressing, to identify contracts and grants that are wasteful, abusive, or inconsistent with leadership's policy priorities. Ramada and his DOGE colleagues have been granted access to department information technology and data systems. These systems of records contain many of the plaintiffs' personal information, including marital status and all of the other things that we talked about before. The government says DOGE affiliates at education and need access to this information in order to audit the system, the student loan program for waste, fraud, and abuse. Ramada states that DOGE affiliates will access tax-related information in the education's systems of records in the future with appropriate authorization and for purposes consistent with applicable law, such as conducting analyses to estimate costs related to student loan repayment plans, awards, or debt discharges. But neither Ramada nor the government explain why he and the DOGE affiliates at education need such comprehensive sweeping access to the plaintiff's records to audit the student loan programs for waste, fraud, and abuse, or to conduct cost estimate analysis. All right, this is the hammer. She's bringing down the hammer, everybody. This is the moment here. She's saying, what do you need that information for? I'm not sure that you actually need that. Fingerprints on our birth certificates? Oh, I don't know. I mean, they'd be pretty small, right? I mean, are they the mom's fingerprints? I don't know. I tell you what, they do the footprints and that stuff, but I don't know if you could, I don't know about that. Really, as part of a background check? Yeah, I know, they had to. They did background. They go through and do a lot of tests before you can actually take the bar exam here. And there's a lot of things that they look up. Actually, I got rejected. As a quick side note, my first time that I applied to take the bar, the very first, I was still in law school. I was like doing what everybody else was doing. And it's the first time I really was like scared out of my mind because they sent this letter saying, you did not accurately fill out the entire form. And I was like, what? And they said, well, you have this one criminal situation. And I was like, what? Because I kept thinking, I'm like, well, I didn't get caught, so I've got no record. Anyway, what happened was that my name change had been put in the wrong category. So I was like, I just changed my name, people. The number was put into the system incorrectly. So I was like, hey, can you guys fix that? That's a problem. So, well, yeah, I mean, right? If a tree falls or if you don't get caught, did you really commit a crime? Oh my gosh, that's not legal advice. I'm just letting you know, right? It was a long time ago. Long time ago. Statute of limitations was run on any potential offense. Oh my goodness gracious. All right, footnote 10. Notably, at least one of the education systems of record, most private information can be masked with a dummy data. That's interesting. There appears to be no precedent with similar facts in other Privacy Act cases where the need to know exception is invoked. All right, so Uh, let's see, the dispute typically involves the alleged unauthorized disclosure of one record. This case involves the alleged unauthorized disclosure of millions of records. Even under existing precedent, this appears to be unlawful. Oh my gosh. Millions of records, everyone. No! Ah, all right. It may be that with additional time, the government can explain why granting such broad access to the plaintiff's personal information is necessary for DOGE affiliates at education to do their jobs. But for now, the record before the court indicates they do not have a need for these records in the performance of their duties. I really like this judge, everybody. This judge is great. Oh my gosh. All right. And then we're citing case law and prior rejected arguments out of cases. So here's another one. And again, I'm kind of skipping through here just a bit. The full case decision is available online if you are interested. Next, OPM. So at OPM, the DOGE affiliates outnumber their counterparts at education. OPM DOGE affiliates include Greg Hogan, the CIO, and numerous OPM employees who have been granted access to OPM's system of records to contribute to facilitating the president's initiative related to workplace reform, including the deferred resignation program that closed on February 12th. I'm going to pause here for just a minute. And every time I read this or I hear this, facilitating the president's initiatives, I think to myself, you know, Mr. Trump is not the one setting out these initiatives. You know, he's not the one that's saying this is how we want it to be. No, somebody's feeding it to him and he's, telling everybody it's his stuff. So every time I read this, I keep seeing that visual. Like, here you go, Mr. President. Really? What's this? Can we go get, KFC later? Yeah, woohoo, throw some ketchup. He's not coming up with these initiatives. This is all some crap being fed to him. And so every time I think about this, it's just like, fingernails on a chalkboard. Fingernails. Exactly. Heritage. Yep. P25. Exactly. And they say it in some kind of a way that makes him think he's like important or actually doing something. So, fingernails on chalkboard, everybody. Hogan's duties are defined by statute. The CIO of an executive agency, including OPM, is generally responsible for, among other things, developing, maintaining, and facilitating the implementation of sound, secure, integrated information technology architecture for the executive agency and promoting the effective and efficient design and operation of all major information resources management processes for the executive agency, including improvements to work processes of the executive agency. So to me, it's what the judge is saying here is, this is what his job description is. So tell me how the information that they are taking is needed in order to do this. So tell me how we're promoting the effective and efficient design and operation of all major information resources needs to have that private information. Like, what do you need this person's social security for in order to make this happen, right? So I think she's doing a great job, kind of setting that out. And then he's going to go in and say, we need that information. And she's saying, you really don't. Yeah, so here we go. Coming into her wrap up of that. None of these workplace reform measures appears to require an OPM employee to access records with the sensitive personal information of current and formal federal employees. Yet some OPM personnel who are implementing the directives in the workforce executive order apparently have access to sensitive OPM record systems that contain this information, which includes the personal information of some of the plaintiffs. So there we go. She's saying, you know what, y'all don't need it in order to do your job that is set out by statute. All right, so moving forward. And she's just saying here the plaintiffs have shown a likelihood of success on the merits. So that piece of it again has been met. Once you meet all of your pieces of your test, then you go forward after that. So next up, irreparable harm, which is where we've had some problems with a couple of the cases getting temporary restraining orders where the judges have said you haven't shown this kind of harm. So she's setting out why they've got the harm here. To establish irreparable harm, the movement must make a clear showing that it will suffer harm that is neither remote nor speculative, but actual and imminent, and that the harm cannot, oh, I'm on the edge of my seat, everybody, cannot be fully rectified by the final judgment after trial. And this is where the test came from. Ooh, Steak and Shake, yum. The plaintiffs have made a clear showing that they are likely to suffer irreparable harm without injunctive relief. DOGE affiliates have been granted access to systems of records, and that some contain sorry everybody, where'd we go? Systems of record that contain some of plaintiffs' most sensitive data, so security numbers, date of birth, home addresses, income and assets, citizenship status. Yes, I think we figured out what exactly it is that DOGE is looking for, everyone. Right? Right? Because if they can access your citizenship status and your home address, then I think we now know what it's really about. And disability status, and their access to this trove of personal information is ongoing. There is no reason to believe their access to this information will end anytime soon because the government believes their access is inappropriate. Is appropriate. I'm going too fast, everyone. I'm getting tangled up here. This continuing unauthorized disclosure of plaintiff's sensitive personal information to DOGE affiliates is irreparable harm that money damages cannot rectify. So she's saying money's not going to be enough, and that's where our irreparable harm comes from. And once you've got that irreparable harm, then you've met that. You've met that piece of the test. Because of the equities and public interest, so this is the last piece, the balance of the equities and public interest merge when the government is the opposing party. So again, we've got a little bit different direction that we go in when the government's the party, the defendant. The plaintiffs have shown that education and OPM likely violated the APA by granting DOGE affiliates sweeping access to their sensitive personal information in defiance of the Privacy Act. There's generally no public interest in the perpetuation of unlawful agency action. So again, we've got, if it's an illegal action, you're not going to be able to find much protection in the laws because of that. Well, let's do one more here because we've got the government argues that preliminary injunctive relief would harm the public interest because it would limit the president's ability to effectuate the policy choices the American people elected him to pursue by limiting his advisors and other employees' ability to access information necessary to inform the policy. The temporary injunction in this case does not prevent the president from effectuating the administration's policies. It prevents the disclosure of the plaintiff's sensitive personal information to DOGE affiliates who, on the current record, do not need to know that information to perform their duties. The balance of the equities and public interest favor temporary injunctive relief. The plaintiffs have established that they are entitled to a temporary restraining order. All right, so there's her justification, everyone, her analysis. And so this final page is where she puts the scope of the injunction. So, it needs to be, oh my gosh, I tell you what, federal employees, everybody, yikes. All right, let's see how far the injunction hits. Yeah, that's one of the big questions, NATO, is that it's a bit late. That's one of the reasons why she is willing to go down this road is because there's already been too much time has already passed. Scope of the injunction. Injunctive relief grants full relief needed to remedy the injury to the prevailing party, but it should not go beyond the extent of the established violation. So it needs to be very particular, very specific. Whenever the extraordinary writ of injunction is granted, it should be tailored to restrain no more than what is reasonably required to accomplish its ends. Judge Chutkan I got you. Hold on. Yep. Had said the same thing. So, I mean, when she was going through and explaining, you need to have it narrowly tailored. For the foregoing reasons, it's hereby ordered, pursuant to Rule 65B of the Federal Rules of Civil Procedure at 8 a.m. on this 24th day of February. The plaintiff's motion for temporary restraining order is granted in part and denied in part as follows. The U.S. Department of Education, Denise Carter, the acting Secretary of Education, their officers, agents, servants, employees, and attorneys are enjoined from disclosing the personally identifiable information of the plaintiffs and the members of the plaintiffs' organizations. Keep in mind, again, we're at almost 2 million people in this batch of organizations, so that's why that information was right out the door at the very beginning. So 2 million people here, about, or 1.5 to 2 million, to any DOGE affiliates, including Adam Ramada and 5 other individuals primarily working on the DOGE agenda at the Department of Education until March 10th. So that's when we're going to have our next hearing here. So she's saying you can't give any of that information to the DOGE people. B, Office of Personnel Management, Charles Ezell, the acting director of OPM, and their officers, agents, servants, employees, and attorneys are enjoined from disclosing the personally identifiable information of the plaintiffs and the members of the plaintiffs' organizations to any OPM employee working principally on the DOGE agenda who has been granted access to OPM records for the principal purpose of implementing the DOGE agenda, other than OPM Chief Information Officer Greg Hogan, until March 10th. Again, that's when our hearing is. And the plaintiff's motion is denied as to the U.S. Department of Treasury and Scott Bessent, the Secretary of the Treasury. So I think the Treasury took it too far. So that was a step too far because there are other cases specific to the Treasury. The plaintiff shall post security in the amount of $10,000 by February 28th. The parties shall meet and confer to discuss a schedule for the production of the administrative record and confer to discuss a schedule for the production of the administrative. I'm sorry, everybody. I've got backwards here. Sometimes I talk too fast and I get tangled up. Let's go back. The parties shall meet and confer to discuss a schedule for the production of the administrative record. Any requests for limited discovery, this is so important. Anytime we get an order for discovery, that's a win, everyone. All right, that's a win because that's when we're starting to actually look at what they're doing. They're not telling us what they're doing. We're not able to really figure out exactly what they're doing until we have evidence. And so any discovery that's being ordered is really, it's a huge win for us. And a briefing schedule for a preliminary injunction motion and shall file a joint status report on these matters by 5 p.m. February 25th. So by tomorrow, we should have a joint status report. The court will conduct a conference call to discuss the information in the joint status report on February 26th. We've got some hearings set up here. At 11 a.m., chambers will circulate call-in information to counsel, and a public access line will be posted on the court's website. Signed, Deborah Boardman, United States District Judge. Whew, that was a lot, everybody. It was a lot. It was a lot. That was 33 pages. But this is what, she was very careful. And she set out, I've got jurisdiction, I've got precedent, I'm setting everything out for if there's an appeal from anybody that they can walk back and look at the precedent I'm using. And specifically, too, again, to say this is the job that you've got and the information you want is not something needed for your job. It's Always Sunny in Philadelphia has the same issue. Well, it happens sometimes. Oh, my goodness gracious. I've been talking too much today. So what are our thoughts? I think this is a really great order. I think this is going to be helpful for the other judges. Again, we have, a dozen DOGE cases going, and they're all on overstepping authority, privacy issues, class action. The only class action suit is against Musk. We also have some questions. This has been kind of batted around a little bit. I don't have all of the information, but there's some question about whether or not there has been some violation of classified information. And we might be seeing a lawsuit coming in down that road too. So, you're welcome. You're welcome, everybody. You are very, very welcome here. Now, again, I've got, and just to remind everybody here too, we have a ton of litigation going on. I did go over and do kind of a pregame show on the TikTok, but just to give you some idea, These are the ones that I just printed today of the hearings, the temporary restraining orders, the appeals, all of them in here. And I'll go through and read these at some point. Oh, of course, you're welcome. You're welcome. Yeah, I'm not sure. I'm not sure who they're from. I refuse to call them that because that's just stupid. It's like talking to a 16-year-old high schooler. But we've got a lot of things going on right now in these cases. So I am just doing quick, brief updates for everyone so that I don't bore you all. How do the courts know if they are honoring the TROs? Great question, John. One of the things that I would say is that each of these cases are individually filed. So we've got, 86 cases approximately. So you've got 86 sets of attorneys, 86 different people who want to have their case done properly, as compared to the Department of Justice, where you probably got like maybe 10, maybe probably more like 5 attorneys handling all 90 cases. So what happens for any case is that the people filing and requesting that restraining order are going to make sure it goes through, because it is that important to them. If you are filing, requesting, going through everything you need to go through in order to get one, you're going to be the best person to let us know if it's been violated. So the people asking for it, they're going to let the judge know, and they do multiple times. Sometimes the judge is like, look, I get it. Stop filing. I got it. Oh my gosh. Do federal judges like being the first in line in a series of similar cases like that? Would they prefer to let someone else go first? I don't think they care. It's a valid question, I would say, but I don't think they care. It really is. Their caseloads are huge anyway. It's just another case on the docket to them. So what I'm sure that they're doing is making sure they know how the other cases are falling, because they are all federal cases, and which circuit they're in, because they don't necessarily have to follow the circuits. They'll want to follow DC circuit, but other than that, they can just kind of, whatever. So they're watching it, but as far as the order goes, no. The judge will make a decision. Like, we have a Washington case that's going right now. Washington case, I can't remember. Oh my gosh, hold on. I'm thinking it's so Washington birthright citizenship case, and there are like 3 other cases that are very, very similar. And so the parties filed to have them consolidated into one case, and that works out great. In other situations, the judge will say there's a case going on in Maryland. Let's pause and wait and see what happens there. So it really will depend on your judge, how busy their docket is, if they really want to have a say in what's going on, or if they're like, this needs to be put on the back burner until somebody else decides it. So, and they can do that. That's within their prerogative. It's amazing. Thank you for keeping us up. Oh, of course. Oh, I'm happy to help. It can seem overwhelming, I mean, I highly doubt most people, well, really, no one in the legal field, no one outside of the legal field is going to be able to just dive in and say, all right, here we go, 90 cases, let's do it. Like, that's a lot. And it's a specialized field that is made intentionally to be complicated for people, which drives me crazy. It doesn't need to be complicated. So then how complicated it is makes it so that people can't access it because they don't know what it all means. It drives me bonkers. Will you be uploading your P25 videos to on here? So, Jean Marie, I'm glad you asked. I have been, basically, P25 is, I carry it with me wherever I go. It's like my albatross. And I'm trying to get them put together. I also have the SAVE Act. So what I'm finding is there's just not enough time. There's not enough time in the day to get it all done. It's on my list. But yes, all of my P25 videos, which I am still planning to put together, will just be up here on YouTube. I won't be doing any more P25 material over on TikTok. And my plan too is to also, all of my cases too, that we're going through, all of the documents like this will be here on YouTube first. So kind of my second tier level things will be if I hop over to TikTok to do a live. But again, this is my primary home now. So my P25 is supposed to be going up here. I've got a new Constitution series that I'm working on. I'm trying to get some of the other big bills that are going on in Congress right now too, breaking those down. So I've got a list. Oh, of course, everybody. Oh, I'm so happy to share my information. There is just so much of it going on. There's just so much, and I wish there could be like two of me or just one fully functioning me would be great. Oh my gosh, do you think at some point Elon could be charged criminally? It's possible. It's possible. Unlikely, and I think it's not going to do anything. I think at this point, truly, he again is very similar to Trump in that he's a bit of a Tinkerbell. Like if he goes down, he just needs applause. He needs attention. That's like how he breathes. And so if there comes a point when he no longer is the center of attention, that will be his downfall. So I think that's the key to it. Thank you. Oh, of course, Kaya, of course. People to your channel. Oh, okay, yeah. No. Hey, I think that's a great question, Jean Marie. I do have some that are already up on my TikTok. I hope they're here. I actually let me make a note of that because let me see if my P25s are over here on the YouTube. Yeah, not that is one of my top priorities. So, oh no apologies needed. No worries. I'm just like bemoaning that I wish I had more people in I had more of myself to do it because it's fascinating and there's just a lot of things that I would wish that I could get out quicker. So that I'm just bemoaning. But no apologies needed. Oh, June Marie, come on, you've been here long enough. We don't need apologies. I'm always thankful when you bring things up because I forget stuff. And I try to do certain stuff and then I forget. So I'm always grateful for the reminder. So no worries. Its process makes me so angry. Executive order implementation havoc. Yeah, shouldn't be able to enact. Yeah, I agree. Our process of executive orders is bad. It's not good, and it's been a huge debate in the legal field for quite a while. So okay, I do have several. That's good. I need to go in and double check, but I think I might still have a couple in the hopper. Come to think of it, that I just haven't posted yet. But yeah, the executive order situation has been law review articles. Like it's probably got to be one of the top 5 law review article topics for sure. What, 60 minutes? Oh no, I haven't. I'll take a look at that. Let me write that down. 60 minutes. Okay. Very good. Yeah. Okay. Yep. Fix it. Oh my gosh. All right. Listen, I've got like a glue stick and some tang. That's the extent of my being able to fix it. And oh my gosh. That's about it. I will pass my knowledge on. All of you go. There's strength in numbers, everyone. I hope they don't settle. Yeah, me too. The Associated Press, I think, really needs to, go forward here. I'm cheering for the AP, man. They've got that case filed. I'm like, let's go. You can do it. No bowling wire and duct tape. I know. I'm not true MacGyver style. Get some chewing gum out. Tang and a glue stick. I know, right? I mean, that's the extent of my superpowers. Tang and a glue stick. I'll even show you. Here's my glue stick. That's it. That's all I got to fix democracy. I can't do any more than that. Oh my gosh. Yes, but it's great with all of you. Yeah, did I say, is it the AP Associated Press? Okay, okay. Yeah, sometimes I get tangled up. I get tangled up. Realize the main stations pay for the. Oh yeah, oh yeah, absolutely. Okay, you're so sweet. Glue stick, right? Check. Now what else do we need? Oh my goodness gracious. Yeah, they do. AP really, hopefully I'm saying it correctly. They really yeah, I mean they open the door for a lot of people. They open the door and make it, especially in my opinion, like the small in rural communities. Like there's no other place where they can really get trustworthy information. So they go to AP. So there, it's important. It's important. Uh, yeah, I mean, I remember CNN getting kicked out. Remember that back in Trump's first term? Maybe it's a Saturday Night Live skit where there was a guy in the cage wearing a diaper, and he's like, "We're not fake news." That was the CNN guy. But there's been problems. But the Associated Press is kind of like, hands off. Like people know that they're pretty trustworthy overall, right? Right? He kicked a cough out. Duct tape, you can rule the world. Man, gotta get some chewing gum. For sure. Yeah, the gold standard, Don't chew the glue stick. Whoops, too late. That one came in too late, yeah. But, that's one thing. If you're like, oh, we don't like you, CNN or MSNBC, we don't like you, but Associated Press, come on. Come on, it's like, right? Right? I mean, come on. It's like the BBC. Like, what did the BBC do to you, man? Let them go. Oh my gosh. Yes, yes. Well, we have to laugh, right? We have to laugh. And I tell you what, as a quick side note, no sniffing the glue stick. Oh my gosh. What's going on with Midas Touch, everybody? Goodness gracious. They are just growing like sweet corn in a field, right? They kicked out Joy. I saw that too. Yeah, that's a bummer. That's a real bummer. Has been the standard. Oh, exactly. So, and I'm telling you though, Midas Touch, that's where it's at. We're in the middle of a revolution here. Uh, Absolutely. And I appreciate the fact that so many of them are attorneys. I really do appreciate that because I feel like the information that they give is accurate. Is very accurate, and that's comforting to me. I can appreciate it. I don't always agree with everything. Like there's a few things where I'm like, man, I don't know. The other side of that could be a little bit different, but the information though is trustworthy, and I love that. And Brian Taylor Cohen, absolutely, absolutely, yes. And Democracy Docket, everyone, I'm telling you, they really don't have that big of a following. They're kind of, I mean, who am I to talk? But they're not Midas Touch numbers, all right. But I love them. They do great work too, over there. So I'm very, very pleased with that. Yeah. So Brian Tyler Cohen, I think one of the things that we have to be careful about, us older people, is that we don't discredit or disqualify somebody just because they're younger. And like the Bulwark, they're a lot younger, and so I think if you listen rather than going forward and saying you're too young, I think that's something that people need to get over, because that's the thing that we had in with some of our legacy medias. You've got some super old people there, and I when you look at Brian, it's like, oh my gosh, he's like 15 years old. I mean, I don't mean any. Well, and Aaron, exactly. I mean, Aaron's like running around. His house is falling apart. He can't sleep. He's having to put a face mask on. He's like dehydrated. He's running around. But get over it. It's there. It doesn't matter. Your age truly doesn't matter. If you go in and do a little research and hang out with these, go hang out on their websites and stuff. Like they've got great stuff. Yeah, Aaron's stressed. That man needs a fruit basket. 23. Yeah. I'm not sure who that. There's another super young guy here. And I can't remember his name, on the TikTok, that does lives. And is it Harry maybe? Harry perhaps? He's like super young. Like I want to make him a like pot of, oh yeah, it is hairy. Okay, okay. I just want to make him some macaroni and cheese. All right. That's every time I listen to him, he's got great information, but all I can think of is like, I bet he likes a mac and cheese with some sliced hot dogs in it. Like I have to get over that. That's like a me problem. That's not a him problem. He's great. But for me, I'm just like, oh my gosh, they're so young. They're so young, and which is wonderful because we need that. We need the next generations to start stepping up. So anyway, that's my own issue. I've got to get through it. Ah, very nice looking man too. Well, I mean, I don't. La 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 la. My hubby's in the other room. Shh. I love gray hair. Gray hair is the best hair. Yes, all three. Yeah, I mean, yeah, and they seem like good people too. I appreciate that so much. They just seem like good people. I love Parker. Okay, yeah, yeah. And it really doesn't matter the age. And I tell you, for anyone who comes in and hangs out with Amanda Rose sometimes on her lives, I mean, she's just, oh my gosh, she's so young, but so incredibly intelligent. And her arguments and how she goes after things is more mature than I've seen out of, 50-year-old attorneys. So she's, amazing. So you really can't judge based off of age, right? She's almost 40. Yeah, she's a baby. She's a baby. If you haven't hit 40, you're a baby. And, again, yeah, you've got to just kind of recognize that that's kind of a me bias thing. It's definitely one of my favorites. I just love hanging out with them. Sometimes though, I'm just like, I gotta go because it just gets to be too much. I personally, the reason why I love Amanda's lives is because I love how the panel explains things. Like I try to learn from them because they try so hard to say, what exactly is it that you're trying to say? And here's some facts and evidence. So go here, here's the site, here's the other site, and try to explain it. And I really, really appreciate that. And so I try to kind of learn from that and think, all right, this is how this helped, or I don't know that helped. So I love that style. Oh, and Bellicose. Oh my gosh, everybody. And Bellicose, of course. Of course, we adore him. We love the Bellicose. We're going to have some big stuff coming up too from him once our things settle down a little bit and we can hop back into the nightmare that is the U.S. Supreme Court. We'll be hearing more. Are you a toddler then? Well, maybe, but it doesn't mean I don't have the most respect for you ever. You're hilarious on her lives. I tell you what, it gets late, everyone. All right. If it's 1:00 in the morning, I'm in, bonkers late. Sometimes I'll leave her live and I'll be like, wait, what did I say? What was that? What was that? Oh my goodness gracious. Yeah, I think sometimes I go a little bit. I go off the rails a bit. So I have to be like, Mom, don't watch that one. Oh, really good times with pickles. Okay. Haven't seen him on lately. Which one? With Harry? Haven't seen him. Oh, and Bellicose maybe. It's funny. Spicy. Well, every once in a while, I just, unfortunately, I do have a bit of a Hulk temper, so I try to restrain it. After dark, yeah. I don't know. That's why I'm concerned if Hawk and I ever get on a panel together, I'm like, what? He's a bad influence on me, everybody. He kind of opens the door like the big brother that starts poking you, and finally you're like, stop it. And so you start arguing. It's so fun. Yeah, that's how I feel about Hawk. I'm like, oh, Hawk's here. All right, no more rules. Let's have fun. Oh my gosh. That's so funny. Anyway, yes. So that's my thoughts on that. That would be fun to see. I agree. Yeah. That would be yeah, I agree. He gets crazy. Well, he's got a lot of, He's got a lot to give. I think the tiger comes out of the cage a lot with Hawk. Sometimes you're like, ooh, dude, put the tiger back. Put the tiger back in the cage for a little bit. And he's like, no. So, all right, well, there you go. Off you go. Oh my gosh. Oh, a couple of times Hawk was really off. Well, yeah, I mean, yeah, he's, we're all different. we all take different roads. Oh my gosh. Yeah, yeah. When his tiger gets out, you never know. That did not come out correctly, but you know what I'm saying, everybody. Oh my gosh. Knitting old lady. Oh my gosh, that's hilarious. Oh, I love it. I love it, everybody. All right, now I'm looking at the clock here. I'm feeling like I'm digging myself into more trouble here. I need to go. Yeah, be like, hey, Hawk, what's going on? You're fun. We love you. Certain people, potatoes. He's got a lot to give. I appreciate the passion so much. She's really good. Okay. I'll have to check it out. We gotta let it out, or else the bear. Well, right, exactly. We appreciate that. With that, my friends. All right, the knitting. Oh, right. I've got it. Let me write it down so I can put her on their list here. That's my French for the day. Oh my gosh. All right. So I'll go ahead and sign off for now, everybody. Thank you all so much for coming and hanging out. Oh, I appreciate it so much. I'm glad we can make it through this order. I think this will be a trendsetter here. I think we'll be referring to this multiple times. But I will keep you all up to date and posted as best as I can. I do have my live that I did tonight on the closet door litigation. That will be the next post that I put up here on the tube. Oh my gosh, I may do another TikTok live, but I should be back here without a doubt later on this week. So take care, everybody. Thank you all again. And moderators, thank you for your hard work. Oh my gosh, I appreciate it so much. You all should get fruit baskets, all right? Fruit baskets for the moderators. Have a great night, everybody, and I'll see you all very soon.